Welcome back, everybody, to another Chattanooga Train Smoke episode of Lockdown 23 in 1. All you gangsters armed up to the gills, man, go up into the club and see your ops. Better think of this case before you get trigger happy. The defendant today is going to be sentenced for opening fire inside of a bar, shooting multiple people, leaving one dead. So let's get right into it, ladies and gentlemen. If you're new to the channel and enjoy all things lockup and crime related, then this is absolutely where you need to be. Hit that like, subscribe, notification bell before you leave. Bear with me as I'm getting used to this fake tooth. And check out my playlist with many more videos for you to start watching today. But per usual, before we get into the courtroom to witness the sentencing, let me give you a little background on the situation. Traveling down to Indianapolis, a judge sentenced a man for his role in a deadly shooting inside a since-closed Broad Ripple bar in March 2024. Following a 3-day trial in March, Nicholas Falk, 27, was convicted of murder, aggravated battery, and 4 counts of battery by means of a deadly weapon. Around 1:30 a.m. Saturday, March 16, 2024, IMPD officers responded to a report of a shooting inside Landshark's bar. Officers working along Broad Ripple Avenue in front of the bar heard the shots coming from inside the business. 5 men had been shot and found on the scene and taken to local hospitals. Another victim drove to an Indianapolis hospital, driving the total number of people shot to 6. One of the victims, later identified as 36-year-old Tim Brown Jr., died from his injuries, and police said all the other victims' conditions were stable. The Marion County Prosecutor's Office said none of the surviving victims were involved in the altercation. Landsharks never reopened after the shooting. According to court documents, detectives learned that 2 women started arguing in a bar prior to shots being fired. Detectives reviewed surveillance footage from inside the bar and city cameras, which showed Falk firing shots and run from the scene with a woman. Surveillance video then showed Falk drive away in the same car he arrived in. IMPD said they took Falk into custody around 10 a.m. Detectives obtained search warrants for the suspect's vehicle, apartment complex, and bags that the suspect and women were carrying. Detectives said they found the clothes Falk was wearing, as well as a gun underneath the driver's seat of the car that had the same caliber as the shell casings found at the bar. Travis Rogers, who co-owned Landsharks, shared multiple clips from surveillance video with 13 News. In the video, you see Falk and a woman walking together. Falk is then seen grabbing a gun from inside the woman's shirt. Minutes later, you can see the gun go off and people duck for cover before running out the front door. The owners of Landsharks spoke and said that the woman who allegedly had the gun in her shirt should also be held accountable. Landsharks owner said that the surveillance video contradicts what she told police. As for how the gun got into the club, the owners of Landsharks said their security guards routinely wand people and pat them down as they come inside. But in this case, the owner said the gun was in the woman's bra, which made it more difficult to search. And from what I read, the female that brought the gun in was not charged for any kind of crime, which kind of blows my mind, whether she knew about it or not, if the guy was going to take the gun and shoot someone. Either way, it doesn't matter. Let's put myself in her shoes. And I'm the one who snuck the gun in somehow and someone ends up dying. I can almost guarantee we're all going to the side pocket for life, or damn near close to it. Who knows though, maybe she was kind of forced to bring the gun in, was scared to say no. I don't know, but a lot of people are upset that she did not get held responsible in any way, shape, or form. Either way, I'll let you do your own research on that. But that is the bulk of it, ladies and gentlemen. So let's go ahead and slap on those khakis and button up blouses. We got to dress to impress the judge. It's smoking day. Sentencing day. All right, here we go. I believe we're going to start off with the prosecution speaking.
Heard from the family today how Tim Brown was a son, he was a brother, an uncle, a cousin, a coach, a mentor. He was a helper. He showed up for people. He made a significant impact on so many people, not just his family, but the community as well. And his family has showed up for him today. I think you can tell by the packed courtroom just how beloved Tim was.
And if I remember correctly, the victim that passed away, he was actually an employee of that bar for quite a while, correct me if I'm wrong. And of course, my condolences go out to his friends and family.
The loss, the impact that his death has had is immeasurable. You've heard the family talk about the physical impact of the intense pain from losing such a key part of their family. But most importantly, Tim was a father. He leaves a little girl a legacy behind. And I know that she will do amazing things with her life because she has the support from her family. When it comes to crafting a sentence, I know that the court has an incredibly difficult task. However, there are some statutory aggravators that I would ask the court to consider. Obviously, no sentence that is imposed, no number of years, will come close to filling the void of Tim's loss to his family.
They're saying that they have some aggravating factors, and there's two kind of factors that could play a role in your sentence. Aggravating, of course, is the bad kind. Things that can make that sentence of yours higher than you could possibly imagine. Then they have mitigating factors that can help you get less time when it comes to sentencing. But if I were to guess, he definitely ain't gonna be seeing nothing mitigating whatsoever come his way today.
Obviously, no sentence that is imposed, no number of years, will come close to filling the void of Tim's loss to his family. But not just him. There were 5 other people that were injured that night. 5 people who had just gone to the bar to have a good time, whose lives were also impacted that night. So I would ask the court first and foremost to consider the nature and circumstances of the case. Mr. Folk circumvented safety measures that were in place. He snuck a gun into a place where guns are not allowed for probably very obvious reasons. You can't have guns in a bar full of people who are intoxicated, it's crowded, it's dark. But he did it anyway. He did it anyway, and then for some unknown reason, perhaps an argument that took place, we don't really know what happened that caused him to fire a gun. And you saw the video during the trial. That gun is pointed straight at the crowd of people. And he fired it again and again and again. And he struck Tim 5 times, and he struck 5 other people. People who then left with broken bones and scars and emotional trauma from that night. Not only that, he terrified hundreds more. That bar, the video is so impactful as you watch a sea of people just drop to the ground, terrified for their lives because of Mr. Folk's actions.
But the prosecution's going to go into more details on the aggravating factors like his past criminal history, stuff like that. It's a little long-winded though, so I'm going to go ahead and fast forward it to the defense attorney. He's about to speak those sweet nothings about the defendant to the judge, see if it helps him get a little leniency.
When you see what was presented at trial, Mr. Folk didn't go to the bar with the intent on any, maliciousness or anything of that nature. What we know is he was at another bar beforehand. Everything was fine. He's outside dancing. He's having a good time at Land Sharks when he's first there. I think I agree. There's nothing that we know based on the case as far as what happened inside the bar. I agree with that. But I started to say he's not someone who went into this situation knowing what was going to happen. I think this is the result of bad decisions that compounded is essentially what happened here. It's not someone who went in, kind of with this evil intent to...
How do we know that if no one really knows what happened in there? This is all purely speculation. There's no proof that he didn't plan on doing any of this. At least from what I heard. I don't know, maybe I heard it wrong.
Do harm to anyone in the bar. Now, obviously, again, he made a poor choice. But I separate that from kind of some things that we know about Mr. Folk. We know he does have 4 children, 2 sets of twins.
Okay.
That he was active and engaged in their life. We know that he was someone who was in school. He was someone who had a job. So he's someone who was trying to be a productive member of society. I think looking at the PSI, kind of his the juvenile things that the prosecutor talked about are kind of indicative of instability as a child, and things that happened to him as a kid. I think throughout that, he has tried to be productive, a productive member of society as much as he can. And I think he's someone who has tried. So I started to say, Judge, I don't think he is, someone who can be considered the worst of the worst. He's not someone who, had nothing going for himself. He has family here in the gallery today. He has people who, kind of he's beholden to, he's accountable to, and who love him, and who, want to see the best for him. looking at all these things, Judge, I think I would ask the court to consider, based on kind of the speed and the chaos, to run some of these counts consecutively, concurrently, not run them all consecutively. I understand the state's sentiments, but basically we know what happened here. This is not something where, it wasn't intended.
That's not good, though, when the attorney's messing up the consecutive concurrencies. Consecutive should never even come out your mouth. Don't even remind him of that kind of sentence. He still gives off good vibes, though. I'd keep him as an attorney for sure.
No, I mean, obviously the jury said it was knowingly, so I asked the court to kind of take that difference into account in terms of the results.
Okay.
I think it needs to be punished, Judge, but I don't think that this needs to be an aggravated sentence. I think, if you're going to craft the sentence, I take the perfect position. You've seen all of the, you've seen all of, the whole case, from beginning to end. So I think you are in a good position. Far be it for me to kind of talk about a number, but I would ask that the court to consider, at the very least,
probation,
a balanced sentence.
Judge, if I may.
If I'm an attorney, I'm always going to ask for probation. I don't care if the court's looking at it as disrespectful. But homegirl says she needs to pick up and say a couple cents. Let's see if she can sprinkle a few more sweet nothings.
Briefly add one thing.
Yes, and then Mr. Folk will have the opportunity to.
Thank you.
There you go. Okay.
Your Honor, we're here for a number of reasons today. Gun violence is a complex social problem. Mr. Falk had an exercised agency that night. We are not minimizing that, although we do maintain that this was criminal recklessness. We are here in part because of our government's abject failure to protect us from gun violence. We would not be here if our government had made appropriate efforts to protect our community from gun violence. So I wish to add, again, that this is a complex social problem that cannot be laying at the feet solely of Mr. Folk. And so for those reasons, we are asking for a more mitigated sentence than the state is requesting.
Well, I'll be. There wasn't no beating around the bush with that one. She was straight to it. We want some mitigating factors with this because it ain't his fault, man. It's the government's fault. Where's all the gun safety these days, man? Yeah, right. I highly doubt she's going to take that as a mitigating anything.
This time, if you would like to make a statement, you may do so, and I'll consider that before deciding on your sentence, sir. Is there anything you would like to say?
No, thank you, Judge.
The pre-sentence report with the correction that was made with respect to the juvenile record, the evidence that was presented at trial, the evidence that was presented during this hearing, Exhibits 1, 2, and A, those were letters presented by both parties.
Hate to stop the honor, but you could have at least apologized to the victims that had nothing to do with the situation.
To read, and then to consider them. The court has considered arguments at counsel.
I think he said you ain't even gonna say you're sorry. See that?
He chose not to, and he's not required to do so. With respect to aggravating circumstances, the court considers Mr. Folk's criminal history and his history of delinquency to be an aggravator. Mr. Folk's history is particularly aggravating in nature. He has a sustained history over many years of constantly committing crimes or delinquent acts. It's also an aggravating circumstance that he was on probation when this occurred. The nature and circumstances, as awful as they are, I'm not going to consider that as a separate aggravating circumstance because I think that that's captured in the 6 separate. Nothing that the court can ever do can bring back a family member or loved one who's gone. And so the nature and circumstances of homicide matters, it's always horrible, and that's captured by the 45 to 65 year
Good point, Your Honor.
With
Good
respect
point.
to mitigating circumstances, I did have the opportunity to read the letter that was submitted by the defendant's fiance. I understand that he has 4 children, that this would be a hardship on the defendant's children. And the court did note in the pre-sentence report that Mr. Folk had some level of instability in his childhood that the court will consider. All of that being said, the court considers Mr. Folk, based on his actions, based on the evidence that the court was able to see during the trial, the videos that were presented, the court considers Mr. Folk to be particularly violent, dangerous, and callous. That's what his actions showed me that night.
And it sounds to me the aggravating and mitigating factors aren't going to have too much of a play when it comes down to sentencing in this one.
The court does not find that these circumstances are unlikely to recur. The court finds that if given the opportunity, Mr. Folk would do something similar again, as his criminal history has shown us.
No good.
And none of us know exactly what Mr. Folk planned to do when he went into the bar, but the evidence shows that at some level, Mr. Folk made a decision that he was going to arm himself for some reason when he was inside the bar. His actions of retrieving the firearm from the individual that was with him and then later using the gun, I don't know what he was planning on doing, but he made a decision that he was going to ready himself to use a firearm. Then he used that firearm in a crowded bar filled with people and shot the firearm many, many times. This isn't a circumstance, this is awful as it would be, this isn't a circumstance where he shot at one person and then it hit someone that was on the other side of a wall. You were in that bar, you saw all those individuals there, and you fired multiple times moving around in the bar. I don't know why you did that, but you were aware of what you were doing. To disastrous effect on the people that were shot, the other people that were in the bar. Six individuals were shot, one was killed, many people were traumatized as you saw everyone running out of the bar, ducking, hiding. It was a completely chaotic, scary scene that was caused.
Cue it.
Given all that, I don't believe
It's gonna
that
be
concurrent
thick.
sentences would be appropriate. Consecutive sentences are appropriate in this matter because all of these 6 individuals deserve separate sentences. That is what is fair and appropriate.
Oh man, his eyes went slightly crooked after that. That's probably the only hope he had was a concurrent sentence. And she threw it right out the window. He's getting nothing but consecutive, which means he's got to do the time for each crime back to back. You know, a lot of times when defendants come into the courtroom with like 50 felonies or something like that, could easily give them like 6 lives. But typically, you know, a judge will consolidate them and make them do time for 1 and give them the rest of the time on probation, usually. That's called a concurrent sentence. And that's what, like I said, most defendants are looking forward to. And the only hope they got, usually, when it comes down to a murder case like this.
Concurrent sentences would be appropriate. Consecutive sentences are appropriate in this matter because all of these 6 individuals deserve separate sentences. That is what is fair and appropriate. And given the aggravators and mitigators and balancing those, a mitigating sentence as to each of those counts also would not be appropriate. Each of these counts deserves to be served consecutively and each requires an aggravated sentence. That is what's fair and appropriate. So for count 1, the sentence will be 60 years. For count 2, 4 years. For count 3, 4 years. For count 4, that's an aggravated battery, that will be 12 years. For count 5, 4 years. For count 6, 4 years.
Is that a
All
calculator
of
I
those will be
hear?
served consecutively, meaning one after the other. I'm going to find you indigent to court costs. I'm not going to order a fine in this matter. Sir, you have the right to appeal both the conviction and the sentence. If you want to appeal, you need to let me know because you only have 30 days to do so. You'll waive your appellate rights if you don't let me know.
Smell it
within
one more
those 30
time.
days. I can appoint the public defender agency to represent you now for purposes of appeal. Would you like me to appoint proper
Smoke.
counsel to represent you?
Yes, ma'am.
Proper counsel is appointed.
But that's a wrap, ladies and gentlemen. It says here, Nicholas Falk was sentenced to 88 years in prison on May 11th, 2026. He was found guilty on charges of murder, aggravated battery, and 4 counts of battery by means of a deadly weapon. And like the court said, they don't know too much intel on the situation. So if I were to guess, a lot of those individuals, man, they're probably part of either an organization or they're just keeping it solid, didn't want to speak about it to nobody. Because typically, you know, the courts, they're good at getting to the root of the problem or the motive. And this one was just left kind of blank and barren. No one really knew exactly what took place. Maybe more will come out when he goes around for his appeal. Only time will tell, but as of right now, he's starting a fresh 88 clip. Definitely glad I'm not in his shower shoes. And look, like I said, bear with me, man. I know my speech is a little deverberated from this flipper being in my mouth. Fake tooth, you know, until this implant goes through. I have to wear this thing for like 3 or 4 months. Either way, I'm out of here, ladies and gentlemen. Hopefully you enjoyed today's episode and learned a few things along the way, like don't be shooting inside of a damn club filled with people, or else, you know, chances are you'll probably get more time than this guy. 88 years sounds like a lot, but honestly, he got blessed. I mean, he took a person's life. In my book, that's guaranteed your life be gone as well. But stay tuned, ladies and gentlemen. I got some clips of inmates inside the old state penitentiary. Not to mention, of course, courtroom sentences. They'll always be flowing, like the salmon of Capistrano. Until the next time, though, as always, y'all be easy, be safe, and stay free.